Hello and welcome to the podcast. I'm Karen Weaver. You might have wondered, with regards to the massive proposed settlement between the plaintiffs and the Power Four conferences, where did these valuations come from? How does one create these valuations? To help us understand that, my guest today is Dr. Dan Rascher. He is a partner in OSKR, and Dan is an expert in the economics of college athletics, particularly as they apply to damages analysis, class certification, strategy, and labor issues. He is also a professor at the University of San Francisco, and he is very familiar with the intricacies of the legal case that everybody is talking about, House versus NCAA. Dan, welcome to the podcast.
Thank you so much for having me, Karen.
I'm real glad to have you here. So let's kind of talk about the overview. Give us a sense. We're approaching, hopefully, a final decision by the judge to potentially settle the House v. NCAA case. You played a critical role in this. Walk us through the beginning and the middle and the end so presidents have a quick snapshot of this.
Yes, certainly. So the House case began, I believe, in 2020, even before the Alston case, if you remember,
I do.
was sort of determined by the Supreme Court. With sort of a final ruling. But the House case was settled, or it was filed, and it was sort of sitting there, and it was really challenging the limitations on payments to athletes for the use of their name, image, and likeness tied to video games, tied to broadcast NIL, and then also tied to the individual athlete NIL payments that athletes are able to earn on their own, through an endorsement or something like that. And so that process we were in the process of doing that case. And so my role really is, as an economist, I'm trying to help them figure out the liability questions, right? Are the anti-competitive acts that the plaintiffs claim the NCAA was doing, are those outweighed by pro-competitive justifications that the NCAA might have? So you go through that process. And then also, if in fact it is determined that the anti-competitive acts are not outweighed by the pro-competitive justifications, then what are the damages that are taking place against these athletes in the past? And so I was measuring the damages from video games, broadcast NIL, and then what we called the lost opportunity NIL. And the damages stem from what was going back to 2016. So the statute of limitations in these antitrust cases are usually 4 years. And so the case is filed in 2020. And so you can measure damages back into 2016. And so that's sort of the process I was doing, assuming that those rules weren't in place in 2016.
Okay. And one thing I want to make sure my audience understands, when you talk about anti-competitive versus pro-competitive, for those who've loved college athletics over the years, why is that even an issue in college sports? We have teams that win, we have teams that lose. Not to be facetious about it, but how was what the NCAA doing claimed to be anti-competitive?
Right. And so in an antitrust sense, the question of being anti-competitive and pro-competitive really applies to all sorts of industries, not just sports. We think of competition in sports as being on the field, but there's really the business competition that occurs between the universities when they recruit athletes. And we know that that's a very vibrant market, as we see right now with athletes, moving around from school to school. And so in that process, should the schools be required, based on antitrust law, to compete for the athletes and not have some sort of collusive price cap? And so that's what's been challenged, going all the way back to the O'Bannon case, through the Alston case, and now through the House, Hubbard, and Carter cases. So as we get into the settlement's really around those three cases: the House case, the Hubbard case, and the Carter case.
And these are all former athletes or current athletes who've said, you're illegally restraining our abilities in the marketplace because you limited basically our compensation to tuition and fees, room, board, books, and then I think we threw in what we call the Alston money. Is that pretty much it?
That's right. Tuition fees, room and board, books, and then the miscellaneous, what used to be called laundry money, and we sort of earned that at the end of the O'Bannon case. And then you mentioned the Alston money. That's for academic achievement that the athletes may have, and schools are allowed to pay up to $5,980 in additional payments for academic achievement. And so now on top of that is sort of the House case. It's like, okay, now is there more that the schools should allow the athletes to be able to earn?
And I think that's the point where people are still wrestling with, well, isn't that enough, right? Isn't a college degree enough? Isn't the opportunity to play four-year athletics and in front of 100,000 people with all the coaching and facilities, isn't that enough? What do you say?
And so I think it's a really interesting question. And of course, what athletes get in exchange for their labor. Now it's not free, right? They put their labor out there, as 20, 30, 40 hours a week, and put their body on the line. But in exchange for that, they have really what is the best scholarship on campus in most situations, right? It fully covers their cost of going to school, plus it has these additional payments like the Alston payments. So I guess from an antitrust perspective, the response would be, well, it might be enough in some sense, but in a competitive market, if you apply the antitrust laws, right, if these schools are willing to pay the athletes more, right, then why shouldn't those schools be allowed to pay the athletes more, and why shouldn't the athletes be allowed to receive that? And so we sort of think about the market for faculty like yourself and myself, and the market for coaches and others who are working at universities, right? The schools are not allowed to collude to sort of cap the pay of those folks. And so, we might ask the same question: aren't the coaches earning enough, right?
Mm-hmm.
And so, really, this is just what would a more competitive market offer these athletes? And what we can see today is some pretty mind-blowing numbers. And you can see that these athletes were very underpaid in that sense in the past, when the amount that they could be paid was capped.
Okay, that's helpful. So that helps set the context, because the NCAA is functioning within American system, which values capitalism, values competitiveness, that type of thing. All right. You then explain in your documents that you broke the different plaintiffs out into different classes. Can you talk a little bit about that?
Yeah, so a lot of these antitrust, like Grant House, who's was a
Yep.
swimmer from Arizona State University, right? He's the named plaintiff in the House case, and Sean Alston, running back at West Virginia, was a named plaintiff in the Alston case. And so in these antitrust cases, a single plaintiff, and sometimes they gather a few more plaintiffs, they file the case, and they don't have the money to pay the lawyers to sort of prosecute the case on behalf of just themselves. So the idea is that if they could sort of represent a class of thousands of athletes,
Okay.
then the lawyers are willing to sort of move the case forward at their own expense, hoping to win and then get their share of the winnings. And so these classes have to be defined in order to create a class action. And so the classes have to be defined in a way that the person like Grant House is able to represent all the members of the class, and that you don't have members within the class that are sort of conflicted. Like if the case wins, do half the members, are they worse off, and half the members are better off? Then you can't have a class that's defined that way. And so we start breaking out these different classes in these cases to sort of fit with the different types of damages. Like men's football athletes can earn video game damages, because as you know, in the past there was a men's football video game by
Yep.
EA,
Right.
and then that was canceled by EA and basically by the NCAA, and then now it has come back. And so men's football players can earn that, but say women swimmers are not able to earn video game damages, so we don't want to put them in the same
Okay.
class. So the classes just sort of allow the damages payments and sort of the uniformity of those class members' arguments going forward.
So it's also based on economic opportunity. If EA Sports wanted to create a video game on women's swimming, that would change the calculation of the class for
Yeah, and that would
women's.
change. Yeah, and that would provide potentially damages for the women
Okay.
swimmers. Yeah, that's right.
Okay. And I think that gets to one of the core issues that Title IX advocates have been saying, is that, well, the market was underrepresented in women's sports. It was underemphasized, under resourced for decades. And now we're just reinforcing the economic disparity in this case by giving most of the money to football players, some of it to basketball, men's first, then women's, and then everybody else. And so how do anti-competitive laws work with that, or even do they work with that?
Yeah, Title IX has been an issue in these cases. I mean, I remember when Ed O'Bannon filed his case in 2009, and the lawyers were sort of asking the Department of Education, like, do NIL payments, do they count as far as Title IX is concerned? And so, and really, no one was getting any answers from the Department of Education, or any sort of judges ruling a certain one way or the other. And so, in those early cases, I would do calculations where I would be calculating damages as if Title IX did not apply, and then I would calculate damages as if Title IX did apply, using sort of the existing ratios of payments that an individual school was doing. So if a school was doing 55-45 men to women, let's say, then I would apply damages in that way. Okay. And so sort of as we went forward, and this is there's some legal pieces. Again, I'm not a lawyer, I'm an economist. So the lawyers said that we're not going to apply Title IX, like we're not splitting this. This is just an antitrust case. And I think Judge Wilkin she's said the same thing. This is an antitrust case. And so when we look in the past, based on the TV contracts is really where the bulk of this comes from. Most of the money from the TV contracts is for football, and then some for men's basketball, and then some smaller amounts for women's basketball and other sports. And as you mentioned, I think the NCAA is finally getting the clue that women's sports are very valuable, and that they're finally starting to promote and to sell those rights at a higher rate. Although I still think they're still quite behind what the market's really going to be willing to pay in the near future. But so our calculations are really based on the size of those TV contracts and what those TV contracts would have paid out to these athletes in the past had they been allowed to. Again, not applying Title IX to those payments. Right. And so I, as an economist, that wasn't my choice. That was sort of given to me by the instruction of counsel based on their interpretation and what they knew from the Department of Education in terms of how to apply Title IX.
Yeah, in fact, I'm glad you mentioned that, because in the reports that you provided me, I mean, you've got folks who argue for the plaintiff side economically, folks who argue for the defense side economically, and then you debate back and forth about why this argument is good, why this argument may not work. Help people understand how that process works a little bit.
Yeah, so prior to last summer when the defendants, which is the NCAA and in these cases the Power Five conferences, were the defendants. The other schools were sort of non-defendant co-conspirators, is what they're called. Yes. And then the plaintiffs are the athletes, right? And last summer they sort of announced that they were heading towards a settlement, and so we all sort of stopped with what we were doing. But what we had been doing prior to that was moving forward in the case. And so I would file a report looking at the economics of doing this as a class action, and then they would have an economist on the other side file a report saying it couldn't be done as a class action, if that's how that person felt. And then I would do a reply, and then they might do a reply, and then we finally got the classes certified, and then we started doing the merits. So, okay, so what are the real arguments here? Not just should it be a class action or not? And so then I'm filing reports, looking at the liability and the damages on the merits for the plaintiffs. And again, they have folks on the other side, the NCAA's economists, who are saying, no, we don't think the NCAA is liable, or we don't think that there are any damages, or the damages are small. And so we're sort of battling that out. And that's how most lawsuits go. And either you settle or you go to trial and you see what the sort of judge or jury says. Once this settlement was announced, then not just announced, but announced that they were sort of going through the process, then the lawyers are basically sitting in a room somewhere, as far as I know. I don't even know actually how they were doing it. Maybe it was Zoom. But they were doing it. They were negotiating. And so they were having us, myself and my team, feed them financial information, mostly just that they had it so they could have it at their fingertips so they can make arguments. And then they settled on these numbers on their own, sort of like the total damage payment is $2.776 billion for past damages, and then the sort of amount that the schools can spend in addition to what they spend now going forward, assuming the settlement goes through, right? That's all negotiated by the lawyers. And then we're sort of, okay, so this is your total settlement. Okay, now we're going to apply that to the different classes based on the House case and the Carter case and the Hubbard case and the cases that I've been working on. I had already sort of measured the damages for all those cases. So now I'm just scaling those damages down to fit each of those, or scaling the settlement down to fit each of those damage classes.
Right.
And then
Right.
applying the numbers.
I think that's what I've heard the most about is how, people were saying, 85 or 9% will go to football because most of it's football that's been mostly damaged and not having these opportunities, which in this narrow view makes total sense to me. But I look at, now we have issues around who's on a roster, who's not on a roster, who gets to opt in, who doesn't get to opt in. How did you play any role in helping define the characteristics of opting in versus opting out, or was that a lawyer thing?
So there's sort of two types of opting in and opting out, right? So non-Power 5 schools can opt into the settlement. So, and it's a little bit of a misnomer. And the reason is that they are going to be paying these damages anyway, whether they opt in or not, because the damages are coming from the NCAA and from the conferences. And so whatever the NCAA has to pay is not going to flow down to the conferences anyway. So like, where I teach at USF, right, they're opting in, whether they want to or not, into the damages payments. But then the other question becomes, do they want to opt in to the future set of rules where there's now going to be, you can offer more scholarships than you could in the past for each sport, but then fewer, you have to shrink your roster sizes if they happen to be large down to that same number of scholarships. And then if you want to spend more money on athletes directly, up to $20.5 million per year per school's athletic department in year one, and then it's going to grow a little bit. Like, schools can either opt into that or not opt into that. And so I'm seeing some schools do it. Some conferences are doing it at the conference level. That's been sort of interesting. And then the other opt-in piece is the athletes themselves. If you're a member of a class, in any class action, I'm sure that you've received like a postcard and it says, you're in some class action involving like ATM fees or whatever. And you can either opt into the class and sort of get whatever it is that they're going to pay you, or you can choose to not opt in and you can always fight your own case or join another group who's fighting the case. So the athletes themselves can also either opt into this settlement or not.
Yeah, that I'm glad you clarified that, because there's a lot of misinformation running around about, particularly, and frustration, I might say, the non-Power 5 conferences feeling like they've had little control over their future because they had no say in being sort of forced into this settlement payments that would be taken out of their NCAA distributions. Did you have any economic influence on how that worked for them, how that was calculated?
No. So these cases were, the House case was just against the Power 5. And so if we had gone all the way through trial, there was no settlement, just the Power 5 would have had to pay. So the reason that the non-Power 5 conferences are involved is that from an antitrust perspective, they are part of the cartel. They are part of the group that all agree on the same pay rules that the court, at least in Alston and O'Bannon, had found to be anti-competitive. I think if we had gone forward, the court would have found the same thing. And so they're part of that cartel. And so even though they might not have had to pay damages had it gone all the way through to trial, probably a case would have been filed immediately against all those conferences using the same sort of, okay, we already won all the liability points, let's just get right to damages, and then would have gone after them on damages. So this settlement by Charlie Baker's really the one who I think put this forward. He's the fairly new head of the NCAA, former governor of Massachusetts, right? He's avoiding even that other future lawsuit against the non-Power 5, probably by these same lawyers. I can't speak for them, but they sort of knew what they were doing. And so that's sort of why the non-Power Five are involved in this, is they are co-conspirators in the cartel, right?
Yeah, I know there's a lot of angst in that group. I've heard rumblings for a
Yeah.
while.
I mean, so have I. I mean, yeah,
Yeah, I'm sure
absolutely.
you, no doubt. Along those lines, last week I was moderating a panel with the president at LaSalle College in Philadelphia and the president at St. Joseph's University in Philadelphia as well.
Right.
Excuse me, I think it's LaSalle University. My apologies to
Yeah.
those folks. LaSalle University. But interesting, same conference. One is opting in, St. Joe's. One is opting out, LaSalle. Completely different reasons. These schools are like 5 miles apart. And you would think that they might be recruiting similar demographics, that type of thing. Both are basketball centric schools. Um, so it was fascinating to listen to their reasoning behind opting in versus opting out and the different strategies. Because I, like so many, thought that it was a conference wide decision. But in the Atlantic 10, they're going to have to redefine what competitiveness looks like, what success looks like, maybe depending on whether you opt in or opt out.
Yeah. So, I mean, some conferences, and I can't think of who at this moment, but they're sort of saying we as a conference are going to opt in.
Yeah.
Or the Ivy Leagues, like, we are not going to opt in as a conference. So it is interesting that some conferences are leaving it up to their individual schools. And of course, the schools control the conference. So maybe, maybe there are enough schools in the Atlantic 10 were like, well, we want to have the choice. Or maybe half the schools are like, we want to opt in, and the other half we don't. So then let's not force each other to do it. So it will be interesting. This is what I think may end up happening, because we've seen this with the adoption of Alston payments and with the adoption of cost of attendance payments, the miscellaneous amount, $3,000 or $4,000 a year per athlete. As we won those cases, and then a bunch of the big schools would jump in right away and start making the payments because they're competing for those athletes. The other schools were like, we're going to do a wait and see. Other schools were even like, we're not going to do it for sure. And then after a year or two or three, those schools start to jump in because they realize that they're at a competitive disadvantage. And so they opt in. I mean, like here at USF, from what I know, we're going to opt in, but it doesn't mean we're going to all of a sudden have an extra $20 million to spend.
Right.
You know what I mean?
Right.
And so we're opting in to sort of have the flexibility to add some more scholarships, but I'm not sure really why, unless you really have some money to sort of throw at it, I'm not sure why you would opt in, because you don't have to let go of your walk-on athletes if you don't opt in. And yet if you opt in, all of a sudden, if you have again, for schools that have big rosters on certain sports, you have to let go of some of those athletes. And for a lot of schools, USF included, those extra 5 or 10 players, let's just say on the men's soccer team, are students who pay tuition, who come to school, who are customers of the university, so to speak. And so they benefit the university. And so to sort of have to be forced to get rid of them is probably a calculation that I'm hoping a lot of these schools are making and deciding whether they want to opt in or not.
And in fact, that's a piece of the LaSalle University president's argument. I don't want to deny people the opportunity to come to school at LaSalle, and they also want to play a sport. So that's how we're thinking about this, which, I think more people should be talking about that. Small privates are under tremendous pressure right now with tuition discounting, with, blowback against the cost of college and how much it costs to go. It's a real issue for some of these schools.
Yes, and it is for us out here on the West Coast
Yeah.
with USF and some other schools. Yeah, we've seen some shrinking student populations, and so everyone's trying to figure out how do we get more students to come to our schools, and athletics, of course, is one of those ways to do that.
Exactly. I want to ask you one more question on this topic, and then I'm going to shift to the other kinds of economic analysis you've done, because I think it's interesting. Tell us what the difference is between broadcast NIL and NIL.
So broadcast NIL, one of my staff members, Glenn Mitchell, started using that phrase early on because we had so many different NILs, right? And we wanted to sort of think about it. So he was calling it BNIL as we were sort of moving through it, and it became very helpful for us. But so the use of one's name, image, and likeness, as you probably know, comes from the right of publicity that we all basically have in the United States, right? If I wanted to take your photo, Karen, and put it up on a billboard and sell coffee or something, right? You would have a right to either say, no, you can't do that, or pay me some reasonable royalty, some reasonable amount of money. And so if you think about an athlete on television running around playing their sport, right? One could argue that that's a use of their name, image, and likeness. And so, you know, now what's really interesting about this is if you look at the NBA and the NFL, and you look at their collective bargaining agreements, they sort of dance around this issue because different states have different right of publicity laws and everything. And this became part of the O'Bannon case early on, and then they sort of moved past it. But in those collective bargaining agreements, the players and the owners basically agree that they agree to like not decide whether the owners have to pay the players for the right of publicity. They just say, look, we're going to give you 50% of broadcast revenue, regardless of whether you have a right to it in a legal sense or it's just part of bargaining. And so that's sort of where we are here is we don't know, at least from my perspective as a non-lawyer, I don't think anyone knows whether the athlete being on TV, whether that's a use of their right of publicity in a certain way. Maybe it varies by state. And so, but we're saying, look, in a competitive marketplace, these schools and conferences would pay the athletes some amount of money in order to recruit them to basically put their name, image, and likeness up on a TV screen as they're playing their sport.
Right.
So it's not really any different than other NIL. It's just it's a different category. It seemed obvious in video games that you're using someone's NIL if in fact you are, or obviously when an athlete is doing some sort of is tweeting about some product or whatever service, right? They're using their NIL. But on TV, we sort of forget about it because that's how we engage with sports. We watch it on TV. So,
And going back to the radio days too. So we've been talking about athletes and their performances for years. We just forget that, there's value to both sides for that performance.
Yeah.
I sometimes use the analysis that a couple years ago, the SAG Actors Guild, which is the group of actors and behind the scenes people who work in movies and television and commercials, they all got together and united and saying, unless you give us our rights under AI and all the other things of how our image is being used, you're not fully compensating us. That may be the next level of where we're going with this, because it's going to be requiring constant readjustment as the technology evolves. Would you agree?
Yeah, I would. And what's interesting about SAG, as you mentioned, is, they have a union, right? So they negotiate all those pieces. And we don't have that right now in college sports. We have that in the pros. We don't have that in college sports. We may get there because, as you know, there's the employee cases that are happening sort of alongside these other cases. In fact, one of them I think is in Philadelphia. But those cases haven't come to a fruition where, okay, all of these athletes are now employees, and so they can form unions, and negotiate. And so, as you know, one of the critiques of this settlement from some folks is that this feels like a union negotiated outcome, even though there's no union, right? It's just the lawyers representing the athletes, in the negotiation room. So it's interesting that we sort of have this what sort of looks like a negotiated union outcome.
So two other things I want to shift away from the House discussion for a section, because you do a lot of other work that, quite frankly, I find very interesting. In one of your reports, you've noted, I have conducted 29 economic impact studies of major intercollegiate sporting events, including multiple bowl games, the college football playoff championship game, and conducted analysis regarding the University of Alabama, Birmingham, the University of Maryland regarding its move from the ACC to the Big Ten, which is very interesting, and confidentially for a mid-major D1 on the economic value of athletics. What have you learned with all this about the economic value that athletics brings to a university?
Oh, it's been really fascinating. So the UAB case really sort of crystallized some of these issues because my business partner, Andy Schwartz, and I were asked by, I think, basically some alums and boosters of University of Alabama, Birmingham, to take a look at some of the rationale for when they had initially canceled football.
Oh, wow.
And so we looked at those analyses and we said, well, this isn't really accurately portraying what football does for the university, right? They
Okay.
were just looking at the profit and loss statement sort of within the athletic department, which, as is missing lots of pieces or has additional pieces that aren't super relevant. So if you're sort of trying to understand what is the economic value of, say, football to the university. And so once we sort of undid that analysis and then redid it for UAB, they were able to convince the decision makers at the time to bring football back. And I think it's done pretty well since that's happened. And so in doing that process, we have done this for a number of schools. Myself and one of my colleagues at USF, Jeremy Howell, who's our faculty athletic rep, he and I did sort of an analysis like that for USF. I just did in the past month for Division II Sonoma State University. I don't know, Karen, if you saw that they canceled
Yes.
athletics. And so some of the folks, I think the coaches and some of the athletes have gone after that, have sued them. And there was a hearing yesterday on that topic about sort of temporarily not letting them cancel athletics and some other things. And so I did an analysis of even Division II Sonoma State, and it was fascinating to see what the school sort of put out as, oh, we're going to save a bunch of money by canceling athletics because we're not going to have to pay coaches. We're not going to have to pay for travel, right? Those are two of the big line items down at Division II. But what they didn't account for, which was a little shocking to me, was that if you lower expenses and you assume revenue is going to stay the same, wouldn't we do that with every business we own? We would just cut all the expenses out and assume the revenue is the same, right? But so their revenue is going to drop. And not only did they not account for the fact that they won't sell tickets and concessions and so forth, but they didn't account for the fact that those 250 athletes at Sonoma State, most of them are going to transfer away and play their sport somewhere else. And most of them aren't on scholarships, so they're paying tuition, and many of them room and board and books and the whole thing. And so those lost customers are going to leave the school. Once you account for that, athletics was actually a net positive to Sonoma State. And so I'm hoping that the judge and maybe the university administrators sort of see it in that light and bring athletics back.
Yeah, it's interesting because we do sort of just do it as a profit loss kind of activity. But you've referenced in another journal article we're going to talk about is that how many times do ADs and coaches and even presidents talk about athletics being the front porch of the university, and its brand recognition, its name recognition binds people together. But we don't account for any of that when we're talking about dropping either programs or single sports. We just say, well, it's a profit and loss statement.
Right, exactly. And those, there's lots of related party transactions. So what I mean by that is if you look at a big line item in an athletic department as scholarships, right? Mm-hmm. Well, that money doesn't, so the tuition portion of that doesn't leave campus. It just goes across campus, right, to the bursar's office or the registrar's office. So treating that the same as like a payment to a coach that leaves campus, right? You want to really think about, well, is that really a loss to the school if for those tuition dollars? And at a school like Sonoma State, where they have excess capacity, those tuition dollars aren't really expenses because it doesn't really cost that much money to have someone sit in my classroom and have me grade them. You know what I mean? And give them their units. And so it just takes some care to sort of go through and figure out the impact of athletics on the university.
So the last thing I want to ask you about, which is sort of in my world, kind of an loosely understood, frequently discussed in back channels, decision making that goes into the cost benefit analysis of breaking the NCAA rules. And some of my listeners, they might be like, what are you talking about? But in some of these bigger programs, especially going forward, if the House case settles, there's a lot of money pouring into these programs. Yeah. And some of these NCAA rules don't really have a deterrence. Can you talk about your research in that area?
Yeah. So we did a study, my colleagues and I. It sort of had two parts. We were looking at the value of men's college basketball players. This was in the wake of that Gatto case where the FBI had sort of caught Nike contractors and maybe employees paying the families of athletes to attend schools that are Nike schools versus, say, Adidas schools or Under Armour schools, right? I mean, of course, now all of that would be fine with with the new rules. But at the time, the FBI found it to be illegal. And so in the wake of that, we were thinking about, well, first of all, why did these schools want these athletes? They're valuable. So we did a study showing that the athletes were valuable, which wasn't surprising, especially in sports like basketball and football that have high revenue. But then the other thing that we looked at was, well, sometimes these schools get caught, and are they worse off when they get caught because they get put on probation and they get punished, and then do they lose out in terms of their revenues? And it turns out that that's not the case. In other words, when a school, and maybe the school doesn't always know it, maybe it's a coach or maybe it's a booster, I don't know, sort of the communication there. But when a school, when an athlete is paid under the table back in the day, and they would go to a school and play, if the school was never caught, then the school got the value of that athlete's services, right? If the school was caught, then they would be, punished in some way. And it turns out that if you look at the way that the revenues grow over time, they go up because the team was better and people were showing up, and then it takes a year or two, and then they figure out that they were caught or probation. When you look at what happens, it doesn't really go down. Like, in other words, they continue to benefit from that breaking the rules and even getting caught, and then they recover from it very quickly anyway. So crime pays is sort of the sad learning outcome there. And maybe that's because the punishments weren't strong enough. I mean, we know with SMU and the quote unquote penalty, right? That was a very strong punishment. But most of the punishments are, you lose some scholarships or things like that, or you can't go to a bowl game for a couple of years. And those are important and valuable things to an athletic department, but not enough to make them, not benefit from having cheated in the first place.
And it brings me back to the whole discussion around Michigan and their sign stealing scandal from a couple of years ago. And there's all this discussion, well, what's the NCAA going to do? How are they going to penalize them? Will they keep them out of the college football playoff? All of those kinds of discussions. And it ended up really not much happened because the legal issue took so long.
Right.
That I think everybody's just like, well, that was in the past. Let's just forget about it.
Yeah, I'm not even sure. I mean, maybe something happened to the coaches, but the coaches had already moved on, right? So it's not even clear. Yeah, I know. It's a slow process. I mean, it sort of opens up the question we have if Judge Wilkin does approve this settlement, is that now there's a new body that's going to watch NIL payments to see if they're fair market value payments that are coming from third parties, not from the school itself. And how quickly will that process occur? If they find a payment that they think is not fair market value, do they do they stop that athlete from going to that school or from receiving that payment as a school? It'll be interesting to watch that process to see if it can be more streamlined than what we've seen in the past.
And I interviewed Tim Nevius, who was starting up an arbitration, to try to negotiate some of these exit clauses and that type of thing. That's going to take time. I mean, it's not going to happen in a week. So I don't know how we think we're really going to regulate this.
I know, because what was interesting to me that we've seen just in the last few years that we hadn't really seen before was state attorney generals all of a sudden stepping up for the flagship university, or the flagship school, probably reaching out to them and saying, "Hey, we want to be able to have this athlete play at our school an extra year. Yes. Can you sue the NCAA?" Right? Sort of unheard of. And so is that going to happen starting, this fall when assuming that the settlement goes through? And
what is the value of breaking the law? It might be breaking the rules. It might be pretty non-existent in terms of the penalty.
Yeah, it'll be interesting to watch for sure.
Now, Dan, this has been a great treat to have you explain some of these things, not only for me, but for my audience, which includes my students at Penn, those kinds of things, because it gives us kind of we can see how we got there, right? And how this legal process has dragged on, but it is still continuing towards the end. And your economic analysis has played a key role. So congratulations to you, your team, and thank you for joining us today.
Oh, it's been a pleasure, Karen. Thank you for having me.
Absolutely.